As our nation embraces more and more in terms of our culture the Black Lives Matter agenda, we tend to move further and further away from the truth when it comes to law enforcement. And we start to see myth after myth start to percolate in our society, and people start buying into all these unreal, ridiculous premises related to crime and law enforcement. And that's what I got to deal with today, because I've talked about a number of these myths before. My absolute favorite of all time, coming from Knowing Better's ridiculous video, where he claimed there was no increase in crime, no crime wave. That was a total myth. We just made things more illegal.
What really happened? Why did the crime rate spike in the 90s and then drop as the prison population grew? Well, I hope by now that you can see that the crime rate never actually grew. We just expanded our definition of what constitutes a crime and what constitutes a jailable offense. We've talked a lot about the drug war in this video, but this holds true for all crime.
Now, as I talked about in that video, which is linked in the description and in the iCard of this video, that was such a stupid, idiotic claim that it almost defies logic that an adult, allegedly sentient human being would put it forward. First and foremost, the chart that he's showing, which is violent crime and property crimes all rolled into one, are all things that were legal throughout. The FBI uses metrics that cover the same amount of crimes over time, so you're comparing apples to apples. Secondly, homicides, which again weren't just made extra illegal for the purpose of generating a crime wave, were always illegal throughout, and the homicide chart also mirrors that. And thirdly, and even more hilariously, when in this chart, or based on this logic, did we start making things not illegal during the mid-90s that caused the crime drop? Again, the idea that an adult human, somebody who used to be a teacher, would put this forward is so ridiculous, which is why it still secures a place as my number one crime-related myth, my number one law enforcement-related myth, because it's so utterly, absurdly stupid, it needs to be highlighted from time to time. However, there's another myth that is often put forward, and I see it all the times in the comments of my videos, and that is this idea that the police have no obligation at all whatsoever to protect you in any way, shape, or form. I get this comment on almost every single one of my criminal justice-related videos, even my last one on El Salvador, which of course, that would have no bearing on that topic at all whatsoever, because a Supreme Court ruling that supposedly says the police don't have to protect you has nothing to do with the nation of El Salvador. But the thing is, like those other myths that I've debunked from time to time, this one is also completely untrue. And the conclusions that the left draws from this untrue myth, that we need to get into the social workers more and really get those social workers into the community because the police don't have to protect you, are also completely asinine, and when you find out what was actually in this case, patently absurd, and of course, the opposite is true. But before we get into this myth, this video is sponsored, so let me chuck it to the sponsor, then I'll bring it back over here, and we'll talk about it on the other side. If you're concerned about your weight, you're not alone. A recent survey showed about half of all Americans are looking to lose weight, and one of the best things you could do for weight loss is go over to ketowithjustice.com and get yourself this amazing keto powder. I've talked about before about how members of my family are on the keto diet, and they swear by the powder over at Keto with Justice, which has 5 different key ingredients that helps jumpstart and prolong the ketosis process, and you can get this for yourself 51% off, 60-day money-back guarantee at ketowithjustice.com. That's ketowithjustice.com. What's the word? ketowithjustice.com. So the idea that the police don't have to protect you comes from 2 different Supreme Court cases, and we will review these 2 different Supreme Court cases because what you find out when you actually look into them is that they are in fact technical Supreme Court rulings based on specific things and aren't actually as broad as proponents of the myth like to put forward. Also, and this is quite important, there are many circumstances where an officer can not only be sued, found civilly liable, fired, suspended, or otherwise disciplined by law enforcement, but criminally charged due to their failure to act, their failure to intervene in very specific situations, like, for example, the Asian cop Tao in the Officer Derek Chauvin case. Remember the Asian cop Tao in the Derek Chauvin George Floyd case? remember how he was not one of the officers that were pinning George Floyd to the ground, and yet he not only faced criminal charges on the local level, but civil rights charges on the national level, on the federal level, along with Derek Chauvin and those other officers that were trying to make the arrest of the resisting George Floyd. Well, one of the reasons and one of the principles behind his charging was that the prosecutors decided that he violated George Floyd's civil rights by not interfering when he saw another officer violating those civil rights. If police officers have no duty at all whatsoever to protect you, then Tao should not have been held criminally liable. However, he was held criminally liable in this situation because, again, there are many situations where police officers' failure to act can result in discipline and or criminal charges. So this is just not true based on the news and the headlines that we see day to day and how officers are charged related to these cases. But what actually is true is quite interesting because, you see, there are two cases on the books that talk about police power and how the police don't have to intervene in certain situations and they can't be held liable for not being able to intervene. But what you need to understand is that police, in terms of federal law, in terms of what the Supreme Court is referring to, is actually just a word for executive offices, executive actions, or similar. So it could cover the police department because that is under the purview of the executive branch, but it also could cover the EPA. It also could cover the Department of Energy or any department that is under the executive branch because the executive branch typically has the police power because their job is to execute the laws, aka enforce. That's where executive gets their name. So these cases, what you actually find out when you look into them, actually don't have anything to do with police departments at all. In fact, the key case where this so-called no duty to intervene actually comes from involves social workers. So the case is DeShawnee v. Winnebago County Department of Social Services from 1989. And the holding was as follows. The 14th Amendment does not require the state to intervene in protecting residents from actions of private parties that may infringe on their life, liberty, and property. So already, when I found this case, when I decided to look into this, when I got that one comment too many, that pissed me off and made me decide that I need to be the one who goes after this myth and figures out if it's true or not. That made me quite suspicious because the Department of Social Services, like I said, are state-sponsored social workers. So when we're talking about police, we're talking about the more broader term, not police departments, and specifically we're talking about the equivalent of a child protective services case because that's what this was all about. But let's get into the facts of the case, and maybe this says that the police can just allow you to be victimized by a crime, watch it happen, and not be held liable for not intervening. So this involves a divorce. When the DeShawnees divorced, their son Joshua was placed in the custody of their father, Randy. Now, Randy eventually remarried, and the stepmother of the child sought a divorce, and one of the things that was cited to the Winnebago County Department of Social Services was that Randy had abused Joshua. When the DSS followed up with Randy, he denied the accusation, and the DSS took no further action, although one of its caseworkers did in fact suspect the abuse was happening because of the frequent visits of Joshua to the hospital. He suffered many bruises and head injuries, and he briefly spent time in the temporary custody of the hospital pursuant to a DSS recommendation. A child protection team eventually decided that Joshua should be returned to his father. Several months later, Randy beat Josh so viciously he fell into a coma and suffered from devastating brain damage. After that, Joshua, with the help of his biological mother, filed for damages against the DSS in order to pay for the assisted living of Joshua, who was required to stay in a facility due to his brain damage for the rest of his life. So this is the case at hand. This has nothing to do with law enforcement or regular, ordinary law enforcement, as people think of it in terms of police departments. This is all about the social workers completely and utterly failing to protect a child, and that child being returned to the custody of the abusive father. Because again, social workers that work for the government, child protective services, all these social service departments do not have a great track record with your children because these people are never going to care about your kids as much as you. However, this is not a regular police case or anything like that. In fact, law enforcement officers, nurses, and hospital workers have this thing called a duty to report, where if they suspect some level of abuse, they have to refer it to organizations like the Department of Social Services because they're supposed to handle it. However, what the Supreme Court ultimately ended up ruling is that what the 14th Amendment is designed to do is to protect your right to due process from the government. So it's to protect you from abuses from the government. It's not meant to protect you from private parties just because the government bungled the case and returned you to that private party. Now, the court also said that this claim is properly brought under the substantive rather than the procedural component of due process. Due process does not give rise to an affirmative right to government assistance with protecting one's life, liberty, or property. The government cannot be held liable for injuries that might have happened if it had provided certain services, if it has no duty to provide those protective services. At the time the government returned the child to his father, he was not in a worse position than he would have been had the state never taken custody of him, and that the government does not assume a permanent guarantee of any individual's safety just because they provide certain protection for a temporary period of time. That's it. That's the holding from the court. That's their ruling. Their ruling was that the social workers, just because they protected the child for a temporary period of time, are not obligated to guarantee perpetual protection of that same child. That's what the court ruled. And if the child was injured during the time that they had protection of the child, obviously they would be liable for that situation. But once they determined that the child could be released to the father, and by the way, this is a wrong decision, obviously, they are not obligated for the damages that that third party does. So as you can see, this idea that police departments across the country are unique in that they don't have to protect you from anything and they're evil, bad people and you shouldn't trust them and we should send in the social workers is not supported by this case. In fact, what this ruled is that any executive branch agency is not obligated to protect you from harm from private third parties that have nothing to do with that agency. Now, that doesn't mean that the social workers that investigated this case can't be fired. That doesn't mean that the state, in this instance, can't pass laws to hold their workers criminally liable for these kind of actions. What it means is that if a third party does you harm, but at one point you are in contact with a government agency, that does not then confer responsibility for the damages you suffered onto that government agency in the terms of monetary damages. Now, the next case is the town of Castle Rock v. Gonzalez, and I believe this was decided in 2005, and this is also a divorce case. So like I said, this is another divorce case, and during the time that this divorce was filed, the wife, or the soon-to-be ex-wife, actually accused the husband of stalking her and demanded that the court grant a permanent restraining order against the husband, and this restraining order was in fact granted. However, there was a specific carve-out in the restraining order that granted this father the right to visitation with his children in very specific times as outlined by the terms of the divorce agreement and the restraining order. However, and this is absolutely crucial, Gonzalez, the mother in this case, actually went out of her way to turn over the children to the father extra amount of times that were not related to the times outlined in the order. So there were violations prior to this of the restraining order, but these were consensual violations due to the mother turning over the children to the father an extra amount of times. Now, this is absolutely crucial because on one evening, the crucial evening in question, the mother calls the police and says, "Hey, my ex-husband has the kids. I don't want him to have the kids. He actually abducted the kids, and I need the police to come out." And she calls a few times and then eventually goes out to the police station, and she wants the police to go search for the children because she believes that something is wrong and that this violation of the restraining order is somehow different than the other consensual violations of the restraining order. Now, the police, which this often happens in cases like this, say, "Hey, look, we're going to wait a little bit and see if he comes back with the kids." And what ultimately ended up happening was that the father showed up to the police station and started to open fire on the police officers. The police fired on the father, killing him, and they discovered that in the vehicle, the father had already murdered all 3 of his children. Now, eventually, Gonzalez sues the police department because she believes that their failure to act resulted in the murder of those 3 children, but she sues specifically under a weird constitutional question related to property rights that we have to get into so you can understand the holding of the court in this case. So the question of this case is, can the holder of a restraining order bring a procedural due process claim against a local government for its failure to actively enforce the order and protect the holder from violence? And in a 7-2 decision, the court ruled that Gonzalez had no constitutionally protected property interest in the enforcement of the restraining order, and therefore could not claim that the police had violated her right to due process. In order to have a property interest in a benefit as abstract as enforcement of a restraining order, the court ruled Gonzalez would have needed a legitimate claim of entitlement to the benefit. The opinion from Justice Antonin Scalia found that state law did not entitle the holder of any restraining order to any specific mandatory action by police. Instead, restraining orders only provided grounds for arresting the subject of the order. Specific action to be taken is up to the discretion of the police, and quote, "This is not the sort of entitlement out of which property interest is created." The court ruled that since the state of Colorado has not created such an entitlement, Gonzalez has no property interest, and the due process clause was therefore inapplicable. Now, when you read through the holding, what you ultimately discover is that there is no general right for the police to refuse you protection or anything like that. In actuality, what Antonin Scalia ruled in his holding, and again, you can read it for yourself, I'll link the sources in the description of this video, is that the state of Colorado did not create the entitlement necessary, which was a property interest, for this woman to bring this case forward in the manner that she did. Had the state of Colorado outlined this specific entitlement in law and had any other state done similar, then they would have been eligible to be sued for the actions or inactions that they took under the law that was passed under the state. This did not exist in the state of Colorado, so what Antonin Scalia ruled was that technically this was not a violation of her procedural due process rights. So in reality, this myth of the generalized right to not be protected by the police or the police to refuse to protect you does not exist, even in the 2 specific cases that are brought forward as citations for this premise. Essentially, what Scalia said, which was what was just outlined by the Colorado law, is that the restraining order and violations of the restraining order provide a probable cause for law enforcement to investigate and to initiate an arrest at their discretion. In certain instances, they might give an extra warning to the person under a restraining order, but unless the state of Colorado outlines that the police must arrest, and by the way, this isn't a crazy idea, this is something that exists in domestic violence cases, very famously in the state of Nevada, where they don't require the woman or the victim of domestic violence in any specific situation to press charges. Law enforcement can press the charges themselves and remove a party from there. Then you cannot sue for a lack of procedural due process, which is how this case was brought up. Basically, what he's saying is that this benefit is in the abstract, and since it's not a solid benefit, it has no monetary value, so the basis for suing for money in this instance is just not valid. Now, you might not like that ruling, you might not like the way that the state of Colorado had that law at that period of time, but what I suggest you do, rather than just make up things about how the police have no obligation under any circumstances to protect you from anything at all whatsoever, is to advocate for your state to change the restraining order law so that it aligns with what the constitutional basis would be if a circumstance like this happened again. Now, if there are more cases that supposedly say that the police never have to protect you under any circumstances, feel free to send them over and I will gladly look through them. But what you actually need to know is that this myth is just that. It's a myth. What the police are and are not obligated to do is largely dictated by local law and state law, because police are most likely, 90% of the time, a local and state office. They're not something that is covered by the federal government, and largely what was ruled in at least half of these cases is that the local laws are what dictates it, and the court will not override what the local government does. So, your state might have many different circumstances where police both on and off duty are obligated to intervene in specific situations at risk of being fired, or at risk of serving jail time, or at risk of liability that could be inflicted on the city. Other states might have relatively few instances where the police are obligated, both on and off duty, to act in certain situations. Again, check your local laws, and if you don't like the results, the outcomes of these specific cases, maybe start advocating for changing those laws. Just putting that guarantee in Colorado law would have completely flipped the obligation and put them on the hook for this action. Again, some changes around with the Department of Social Services in that original case in the local laws might have also created that obligation, but the court wasn't going to create it whole cloth out of nothing in order to apply it because they felt bad about the individual case. Anyway, I hope this clears everything up for you. I hope you learned something, and if you did or you didn't, remember to like the video regardless and leave me a comment telling me how great I am. And if you liked the video, like I said, show me by leaving a like, subscribe for more content, follow me on all my social medias, support me via the support links in the description box of this video. This has been me talking about the myth around police not being able to protect you or not having to. Till next time.